Ladies and gentlemen, good evening. My name is Professor Liz Stewart. I'm the Deputy Vice-Chancellor of the University. And it's my pleasure, on behalf of the Vice-Chancellor, who's very sorry she can't be with us this evening, and indeed the whole University, to welcome you to this inaugural lecture of Professor Anat Scolnicov. Anat was born and grew up in Jerusalem, and she grew up in a family of academics. Her father was a professor in ancient philosophy, and her mother, who we're delighted to have with us today, is a professor of theatre studies. Her grandfather was a renowned chemist, one of the founders of the Scientific Weizmann Institute in Israel. So she came from a family that spanned the arts and science. She did not always want to become a lawyer. As a child, her grandfather would take her into the lab and nourish her interest in science. However, as Anat's schooling continued, she found herself more connected to her parents' interests in philosophy and the social sciences. Anat studied law as an undergraduate at the Hebrew University. She was editor of the Law Review and graduated cum laude. She then moved to the United States to study her master's in law at the Harvard Law School, where she held a Fulbright scholarship. She returned to Jerusalem to practice as an attorney for the Association for Civil Rights in Israel, working on civil rights legislation and Supreme Court litigation, with a specialization in freedom of speech, freedom of information, privacy, and freedom of religion and conscience. After working for 7 years as a lawyer, Anat decided to move into academia. She came to the UK to do her PhD at the London School of Economics, focusing on religious freedom in international law. While doing her PhD, Anat took up a job at Cambridge University. She was Director of Studies and College Lecturer at Lucy Cavendish College. And from 2008 to 2013, she was also Deputy Director of the Centre for Public Law at Cambridge University. Around that time, we were looking for someone to join our law department who had a strong research background and an international perspective and reputation. And I was delighted to chair the panel which appointed Anat as Professor of Law here in 2013. Because Anat's research is very much in line with the university's values, particularly those of social justice and individuals matter. Her research into human rights covers topics such as women and children within religious groups, conflict within religious groups, and the right to access education. And since working here, Anat has had numerous opportunities to influence debates about international human rights. She's been invited onto a UN expert group to advise on the rights of religious minorities, has been involved in various meetings with UN diplomats from various countries, particularly where conflict between law and religion comes into play. Needless to say, Anat is a hugely influential and inspiring academic. It's the mission of this university, through its teaching and research, to make the world a better place. Anat personifies this completely. Ladies and gentlemen, please join with me in welcoming Professor Anat Scolnicov.
Good evening. Thank you to Professor Stewart for that kind introduction. Thank you also to the Vice Chancellor and the Research and Knowledge Exchange Center for inviting me to give this talk today. I want to thank all of you who have come to hear this talk on a rainy evening, particularly to those who braved the vagaries of British public transport. I see here some students, former students, colleagues, friends, including those who have come from London and Cambridge, my dear mother who has come from Israel, and I know that my father would have loved to be with us today. So thank you for coming out to hear my talk. And I thought that I would start by telling you about the road that has led me to the research that I'm doing today and to the writing that I want to talk about. As some of you know and others have just heard, I was not always an academic. I started my life in the law as a practicing human rights barrister who touches her mic, yes, in Israel. And what that entailed was challenging government policy and sometimes government law in the courts, particularly in the Supreme Court, and particularly in the area I dealt with, the area of freedom of religion, conscience, and belief. Now, I think that it will not surprise you to hear that Israel has many conflicts surrounding freedom of religion, conscience, and belief. And one of the main reasons for that is that legal power is given by the state to the different religious communities, the Christian, Muslim, Jewish religious communities, over certain areas of laws, and particularly over marriage and divorce. Now, this in itself is a breach of the religious freedom and the freedom from religion of those men and women who do not want their marriages to be subject to religious law. And this has huge implications for everyone's lives. But the problem encountered again and again when trying to challenge any aspect of that law in court was a refusal of the courts to intervene based on an argument that I heard again and again, that this is a matter for society at large to decide and for Parliament to legislate, not for courts to intervene in, even where it was clear that really there is such a breach, and even if there was some constitutional basis for challenging it. So that led me to think that the solution to this issue must be sought in international law. After all, it cannot be the case that human rights are up to the states to decide when to respect them and when not, and some coherent answer must be sought within international law. And that led me to embark on my PhD studies here at the London School of Economics. I wanted to understand what this right to freedom of religion and belief entails. What really does it mean? And that led me back, all the way back to 1648, to the date of the Peace of Westphalia, which we can see here, these gentlemen signing a treaty, or rather one, I think this is in Winchester, one of the series of treaties which constitute the Peace of Westphalia. This was the series of treaties which ended the 30 Years' War in Europe, brought some peace to the region, but also it's an extremely important treaty in international law because it is considered to be the birth of international law, of modern international law, based on the sovereign state. So it is also the birth of the sovereign state as a building block of international law, But also it is important because in these treaties we find some guarantees, albeit limited guarantees, of freedom of religion and belief to individuals. The reason for guaranteeing freedom of religion and belief at this point to Christian denominations only, of course, that was the European world, but nonetheless some guarantees. This was a way to achieve peace between the different powers. But from this moment on, really, international law has changed and taken the modern approach that we know today. Religions have had from this date on, at least formally, a decreasing role in the formation of international law. The sovereign state is, from this day on, the building block of international law, and the sovereign state has the powers, all the rights and obligations in international law, merely by virtue of being a state. That is not true of us, of humans. We do not have rights and obligations in international law unless they are given to us, either in a treaty or, in rare cases, because of a common consensus of state, what is called customary law. Now, customary law on freedom of religion and belief doesn't really exist to any meaningful extent. There is also no universal treaty, no international treaty on freedom of religion and belief or on non-discrimination on the basis of religious affiliation. Now, there are other conventions, other treaties on specific human rights, but not on religious freedom. And that is no coincidence. It is because it was impossible for the different states to agree as to what this right entails. That is true until today. But we do have in international law a provision in the International Covenant on Civil and Political Rights which guarantees religious freedom, freedom of religion, conscience, and belief. Also in the UN Charter, we can see that of the purposes of the United Nations is encouraging respect for human rights for all without distinction as to race, sex, language, or religion. Now that is interesting because there was a choice that was made here to use a language of individual non-discrimination rather than using a language of protection of minorities. This was a conscious choice that was made at this point. And it is also the same choice, the same linguistic but also very meaningful choice, substantive choice that was made at the drafting of the Universal Declaration on Human Rights. Everyone has a right to freedom of thought, conscience, and religion. I'm skipping forward, either alone or in community with others, and in public or private, to manifest his religion or belief in teaching, practice, worship, and observance. So we see again this language of a right to individuals rather than rights to minorities. And this was a conscious choice in both these documents for two reasons. One is the historical precedent. So this was after the Second World War, the attempt to draft this new world order. And the historical precedent that existed at this time was the protection that was offered by international law before the Second World War, that is, between the two world wars, was protection through a series of minority treaties. That is, a series of treaties between states which protected religious minorities. That system proved to be an unmitigated failure. The whole system collapsed, and indeed it was one of the reasons, or one of the pretexts for the outbreak of the Second World War. Be that as it may, certainly the protection of minorities and of religious freedom, religious tolerance through protection of minorities in the Minorities Treaty was not successful. So that was a historical precedent that they had in mind. But there was also a substantial reason for adopting a language of individual rights, as was framed by Eleanor Roosevelt, who was one of the drafters who sat on the committee which drafted the Universal Declaration of Human Rights. She said, "Organized society exists for the benefit of the individual." Now, this liberal view was contentious. It was by no means unanimous. But it's interesting that the other big proponent on the committee of the individual approach, the individualistic approach, was Charles Malik, the Lebanese theologian who, together with Eleanor Roosevelt, supported and promoted this view, which finally, as we can see, made its way to the, in fact, the language of the Declaration. On a historical side note, it's interesting to see that the resistance to that came from the Chinese member of the committee, so the communist Chinese at the time, right, member of the committee, the drafting committee. He was against this approach of individual rights, and there's some historical irony in that, because today we hear resistance or arguments against the individualistic approach, usually from the side of religions or religious states, and it is atheists who want to argue for individual rights. So one maybe lesson to be learned here is how important it is to take a principled approach to human rights and not to follow a political stance of the moment, but again, be that as it may, this was, despite the controversy, was accepted and was drafted, as we can see in the language of the UN Charter, of the Universal Declaration of Human Rights, and later in the International Covenant on Civil and Political Rights. All of these use language of individual protection. I can add to that again from the same period, post-World War II, the European Convention on Human Rights again uses that same language. So it would have seemed that at this point it is settled in international law that the right is a right of individuals. But what we see recently, and when I say recently, particularly in the last 20 or so years, is that a growing trend among some courts, some international organizations, including on the UN General Assembly, and some academics, of promoting a collective view of religious freedom. So both in court opinions and in academic writing, you find that. Now, it is uncontroversial, I think, that the right to religious freedom, even in its framing as an individual right, as we can see, includes also a right to practice, to teach in community with others. Indeed, some aspects of religion, and therefore of religious freedom, are impossible to practice except if we recognize that more than one person needs to practice them together. So whether it's education, worship, religious leadership, certainly more than one person is needed in order for that aspect of religion to be performed. So I think that is uncontroversial. States don't always respect that, but I don't think it's controversial in human rights theory. And indeed, courts, for example, the European Court of Human Rights, were right to recognize that. But where things become more complicated is when today we see more and more that the argument for a collective view of religious freedom is of collective right that could potentially or actually supersede individual rights. And that is something that we encounter more and more. Now, usually, when that conflict arises, the way it is presented is as a conflict between two rights, between religious freedom on the one hand and usually equality, whether on the basis of gender or sexual orientation, on the other. And that immediately raises the question, so which right is more important? But there is no such hierarchy of rights in international law. There is no such hierarchy of rights prevalent in national constitutions or bills of rights. And indeed, I see no principled reason to decide that a priori one right is more important than the other. But I think it's a false dichotomy and it's a false way to present the conflict here. I think that a more correct way to present it is as a conflict between an individual view of a right to religious freedom and a collective view of a right to religious freedom. So claims of individual versus claims of a collective right. And I want to show you that today. And I want to show you that in a number of different contexts. So one will be rights of women, particularly in worship and in leadership. The other will be education. And the last will be a claim of religious freedom by corporations. But even before discussing these examples, you might ask, well, if the International Covenant on Civil and Political Rights promises a right, an individual right to religious freedom, and states have undertaken that obligation by being parties to the treaty, how come this even arises? How can states ignore that or prefer a collective right over it? Now, there are a number of answers. One, of course, some states don't uphold the obligations which they undertake. Other states will have a different view of how to interpret these treaties and their obligation under the treaties, and we'll see that in a minute. But in international law, there's also something quite peculiar. States can join treaties, be parties to treaties, but also exempt themselves from certain obligations in the treaties by entering reservations to these treaties. That's not always true, not to every type of obligation, but the possibility exists even in regards to human rights treaties. So states can join human rights treaties like the International Covenant on Civil and Political Rights and exempt themselves from certain obligations by entering reservations. Now, if you look through the reservations that have been entered by states to human rights treaties, and it's easy to see on the UN website, the majority of reservations have been entered on grounds of religion, and the majority of reservations are reservations to rights of women and children, whether in the International Covenant on Civil and Political Rights or other UN human rights treaties. So clearly this is one important way in which states join treaties but exempt themselves from upholding these obligations. Women are affected in many ways by a collective view of religious freedom. And only this past week, the Supreme Court of India has heard a case in which women in the state of Kerala have argued that they are unlawfully being excluded from the Hindu temple in Kerala. So these women, presumably Hindu themselves, argued that their exclusion by the priests of the temple from the temple, this was a policy of the temple, is unlawful and unconstitutional. The representative of the government of the government of Kerala, argued in the Supreme Court of India that this was a decision of the priests of the temple, and that falls under the religious freedom provision of the Indian Constitution, and therefore cannot be challenged under the equality provisions. At this point, one of the judges asked the representative of the government whether only men had spirituality and if women were incapable of spirituality. Clearly, this view presented by the court, we don't know what the court will decide, but at least it was certainly presented by the judges, is a very individualistic view of religious freedom. It is a view that says, in the eyes of the judges, at least what they seem to suggest in the hearing, that in their eyes, the interpretation of religious scripture by the priests holds no greater value in the eyes of the law than the way scripture is interpreted by, in this case, women, individual women, or it could be in another case, individual men. There is no necessarily greater value to that determination of the priests of how they want to exercise their religious freedom over that of women who had no such role in the hierarchy of the priesthood. So this case is interesting and very important, and I think we should await that decision for two reasons. One, already waiting in the wings is another case being heard in the Bombay Supreme Court, this time of women who were excluded from a Muslim place of worship. So obviously the Bombay Court is waiting for this decision by the Indian Supreme Court on the Hindu temple. But the second reason, and that is very interesting, it's a rare case in which a court is willing to look at the doctrine of a religion, to intervene even in matters of doctrine and say that is not the view of religious freedom as the Constitution, in this case of India, upholds it. Usually courts have a very hands-off approach whenever issues of religious doctrine arise. Thereby, they, in fact, if not in intention, uphold the collective view of religious freedom. In fact, there is a case that was ongoing for over 25 years in Israel of the women of the wall. So these were Jewish women who wanted to pray at the Wailing Wall, the Western Wall, with the Torah scrolls in the same way as men do, and they were not permitted to do that. That's a case that was in the courts for over 25 years because the Supreme Court again and again found ways not to make a decision. And finally, some out-of-court compromise was agreed here. So we can see how unusual it is for a court to intervene even in matters of religious doctrine in order to protect individual religious freedom. And I can compare this case to a case even that has occurred in the United Kingdom recently, or fairly recently, in the Supreme Court. Again, this was an issue of discrimination on the basis of gender by a religious organization. The facts were very different. This was a female lay minister in the Church of Scotland, in the Kirk, who argued that she was discriminated against by the church where she had been employed as a lay minister, been discriminated against in contravention of the Sex Discrimination Act. Now, the argument of the church here was the Sex Discrimination Act does not apply because there is an Act of Parliament, the Church of Scotland Act, which says that in, quote, matters spiritual, the Church will have jurisdiction. So we can see here again that claim of religious autonomy of the collective, here based on a specific Act of Parliament. The court in this case, the Supreme Court, said, well, she's an employee of the Church, and employment is not a matter spiritual, and therefore the Sex Discrimination Act applies, and the case was decided accordingly. So indeed, the outcome of the case is to protect the rights of this individual woman, not the religious freedom of the collective. But what is interesting is the court in the United Kingdom did not go as far as the Indian court. It still is leaving the matter of the jurisdiction of the Church intact. And why do I say that is of particular note? Because we might have thought, as English law always suggests, according to a principle of parliamentary sovereignty, if there is an earlier Act of Parliament, the Church of Scotland Act, and a later Act of Parliament, the Sex Discrimination Act, if there is any conflict between the acts, the court will always apply the later Act of Parliament. Now, the Sex Discrimination Act did not say anything about that exemption for the matters spiritual, as did the earlier Act. The court, we might have expected, would have simply said it's a later Act, Sex Discrimination Act applies, and that's the end of the story. But the court didn't do so, really without any explanation. But we might think that the court was very sensitive to find a way to make a determination on this issue with no interference in that area of religious doctrine which is left to the autonomy of the Church. So that is this English case or United Kingdom case in relation to the other cases. But women have raised the argument that a collective view of religious freedom leaves their religious freedom lacking, not just in matters of worship, but also in matters of leadership, and particularly leadership within religious communities. Because the question here is how should states respond and how should courts respond when political parties, religious political parties, exclude women from being candidates on the party list, whether in municipal elections or general elections, doesn't matter. On the one hand, we have religious parties who are exercising their right of religious expression through participation in the political process, but at the same time, women who want to have the same right to express their religious views through participation in the political process are denied that right. They realistically have to be candidates on a mainstream, some existing party, in order to be able to join the public discourse and the political debate. In Israel, a recent case was of that nature precisely. Orthodox Jewish party or number of parties exclude women from the possibility of being candidates in municipal or general elections. And some women who wanted to be candidates challenged this. But the way they challenged it was they challenged in court the funding by the state of these parties. So all political parties receive election funding, and these women argued that the state cannot be complicit in this exclusion of women candidates by funding a party which excludes them in a way that is discriminatory. The court rejected the petition, did not really explain why, or didn't sufficiently explain why. And the outcome clearly is protecting the right of the collective, these collective, very mainstream political parties, religious parties, whose right to political participation, right of association, and indeed a religious expression is being upheld here by the court, but at the expense of exactly the same right of the women who also wanted to participate in a party that promotes their religious, Orthodox Jewish religious views. The European Court of Human Rights has taken in a similar case a very different stand. This time this was a Protestant party from Holland, which was denied by the state, by Holland, the ability to participate in elections because it did not accept, for religious reasons, women as candidates on the party list. The court upheld here the right of individual women and approved the actions of the state of Holland in this instance, which prevented the party from participating in elections and thereby not accepting this collective view of religious freedom over an individual view. So women are influenced in very many ways, just a few of which I've mentioned, by the decision to view religious freedom as a collective right or an individual right. But this is not the only area in which this decision has very important effects on our public life. And in fact, the next area I want to talk about, I think, is of importance to everyone in this room, and that is education. And indeed, one of the earliest specific religious rights which is mentioned in international treaties is the rights of parents to educate their children in conformity with their religious beliefs, or today in conformity with their religious and philosophical beliefs. So this was one of the earliest specific rights which the state has to respect, but that raises also the question, what happens with parochial schools? Do they have an obligation to accept children whose parents decide to send them to a religious school of their choice? Or can a school rely on its autonomy, on an autonomy of the religious community, and say, we don't think these children fit our school, they're not a part of our religious community? And this is a case that, again, came up in the UK Supreme Court fairly recently in the matter of a Jewish school, which rejected student, did not find as Jewish according to Orthodox Judaism. And the Supreme Court here preferred the right of the student and said this school is discriminating against the student, so it preferred the individual student or the choice of the individual parents to educate according with their religious beliefs over the argument of this organization of the community that it is up to their choice who is Jewish and who is not. So I think this is an important decision and the right decision, but again, on a side note, I would have said, rather than deciding this case as the court did as a matter of race discrimination, I think it would have been better to decide it as a matter of religious discrimination. The reason it was race discrimination in this case is because Judaism, the court said correctly, is an ethnicity as well as a religion, and that falls under the definition of race in the English legislation. But what would happen in the next case if a similar case occurred in a Catholic school? Catholicism is not an ethnicity or a race. What would happen? The case would have to be decided differently. I think that's wrong. I think that there has to be a coherent approach to all parochial schools, and this should be determined as a matter of religious discrimination. The religious choices of the individual child, of the individual parents, are paramount to that of the entity of the collective. But be that as it may, the UK court indeed preferred here the individual right. Now we can see a somewhat different approach in the European Court of Human Rights. In a very important recent case, the facts were very different, but this was a matter of the state, in this case Italy, as a policy approved placing of crucifixes in classrooms, even over the objection of atheist parents. This is in state schools, in public schools, to which parents have to send their children. So individual parents objected, the state rejected their objections, and so did the European Court of Human Rights. So we can see here the court preferring the choice of the collective, in this case the state, over that of the individual. Now clearly it's a very different magnitude of discrimination than the English case. After all, it's very, very different to have your child rejected from a school of the choice of your faith, or to have a symbol of a religion in a classroom, but nonetheless, there still is a certain discrimination involved here when children of atheist parents, parents who have chosen to educate their children either in a different religion or atheism, must go to school in a classroom with a certain very prominent religious symbol. So we can see, although again there's a great distinction between the cases on the facts, but still a choice of the European Court to prefer the collective interpretation of religious freedom to that of the individual. But the choice of the collective religious freedom over that of individual religious freedom has implications not just for the students in the schools, but also for the teachers. And it is often the argument of it is often the argument of parochial schools that it is part of their religious autonomy, their religious choice, to choose the teachers that fit them, fit their religious ethos. And to do that free of, usually the argument is free of state intervention in the form of non-discrimination laws. In the United States, that applies even to Social Security, the state-instituted Social Security. Now that is something very interesting because the United States is perceived as a staunch supporter of individual rights. But we can see that the outcome of this protection of an individual right in the form of the First Amendment, the separation of state and church, has perversely the effect of preferring the religious freedom of the collective over that of the individual. And that is because of a doctrine called the ministerial exception. Now, the ministerial exception was originally meant to exempt churches, or could be organizations of other religions, but churches, in employing ministers, in employing clergy, according to their doctrine, and exempt from having to abide by non-discrimination legislation, so they could choose clergy according to their religious doctrine. But the ministerial exception has been recently interpreted by the US Supreme Court in a much extended way, in a way that applies also to teachers in parochial schools if some component of their job is to do with religion. So even if they are math teachers or music teachers, but some aspect of their job, some part of the day is concerned with what can be termed religious education, the ministerial exception applies. The result being that a teacher who has chosen, because of her faith, to work as a teacher in a religious school that matches her religious choice does not have the same protection as an employee that another teacher who works in a state school would have. So, for example, she would not be protected from discrimination on the basis of her disability. So if a teacher is discriminated against because of a disability, she would not be able to sue the school if her role falls under the ministerial exception. So you can see how far-reaching the implications of this decision on collective or individual religious freedom can be to people's lives and even livelihood. That is in primary and secondary education. But we can ask now the question, what happens in higher education, in tertiary education? Should the balance here be different? Because after all, in primary, secondary education, the state should and does protect the rights of children in loco parentis, but maybe when we are talking about adult students who choose whether to go to a religious college or university or which college they want to go to, they are making a conscious choice here and they don't need the same protection. So will a claim of religious autonomy by a religious college or university where those exist, should that be more legitimate than a similar claim by a primary or a secondary school? This is a big problem that is facing now the courts in Canada and will definitely come up in the Supreme Court, for a decision in the Supreme Court. Because a university, a Christian university, which now also has a law school, asks its students to agree a policy of the university according to its ethos that sex will be confined to marriage in the traditional sense between man and woman. Now, this discriminates indirectly against gay and lesbian students because obviously they cannot come under that definition in any sense. It's an indirect discrimination, maybe not a very serious one. They can be accepted to the university, but they do have to abide or agree this policy. And it is, after all, the choice of the students to attend the university. There are plenty of other good law schools in Canada. But if a Christian student decides to attend that university, a gay or lesbian Christian student, because of their religious faith, they will be facing this discriminatory policy. Now, I mentioned that there is a law school, and that raised the problem because bar associations in the different provinces said, well, we cannot be complicit in that discrimination. Therefore, we will not permit the graduates of the law school to take the bar exam and join the bar association in our province, thereby, of course, rendering the university unable to offer a qualifying law degree, which is, after all, the purpose of every law school. Now, are the actions of the bar associations here lawful? That is the legal question that has led to conflicting decisions in the Supreme Courts of the different provinces. And therefore, it will definitely be decided by the Supreme Court of Canada. And indeed, this is a more complex situation because, on the one hand, there is discrimination here. On the other hand, of course, this argument of the university for their religious autonomy, which, as we said, may have more legitimacy than coming from other institutions. But also we can ask, is it the role of the bar associations to make that determination, to make the determination between the collective and the individual right? Or are they right to say that if they accept the graduates of the university as members of the bar association, as practicing lawyers amongst them, they themselves will be accomplices in this discrimination? So this really, we can see, is a complex legal situation, and the case is also important because, of course, after that will come cases of other professional associations who might make similar or different determinations when it comes to graduates of medicine, of any other profession. So that is maybe some of the complexity of the decision whether to recognize religious freedom as an individual or group right in the context of education. And then lastly, I wanted to talk about another area in which collective religious rights have effectively been recognized, even though not explicitly so. And that is by recognition of a right of corporations to religious freedom. Now again, I think it's uncontroversial to say part of religious freedom, part of individual religious freedom is for people to associate, to form a corporation, whether it's to purchase property, to do other legal activities which they cannot otherwise do. In the same way that they have a right of religious association, they can associate in the form of a corporation to advance their goals. There's nothing, I think, controversial about that. But I think that it is a further step to say that now this new corporate body, this artificial body, non-human body, has human rights, has a human right of religious freedom. And I think these two very different steps have been sometimes conflated by courts. And, for instance, recently in an important decision of the U.S. Supreme Court that decided that at least small corporations have a right of religious freedom. And the danger, I think, in that recognition is that through recognition of a corporate right, what can happen is that that trumps the rights of individuals, such as employees in the corporation. And that is exactly what happened in this case. So this was a small corporation, was an employer, and wanted to be exempt because of the religious beliefs of its owners. Again, it's a question whether religious beliefs of the owners should be imputed to the corporation, but that was what the court did. So because of religious beliefs of the owners, that they wanted to be exempt from paying for substitute of the medical insurance, the Obamacare, for their employees, when that included a certain type of contraceptive. So the court said, yes, there is a right to the corporation, a right of religious freedom here, but what hardly merited any discussion in the case are the rights of those employees who would not be receiving this medical insurance. Again, employees who have made their decision, which should fall under religion, freedom of religion, conscience, and belief, so their ethical, moral decision about how they want to live their lives, and because of this recognition of the corporate right, they will suffer this consequence. So we can see this other area in which a recognition of a collective right has implications that I think are important and so far under discussed. So we have seen the various small number of the very many implications of the decision whether religious freedom, freedom of religion and belief, should be interpreted as an individual or as a collective right. And in my last book, The Right to Religious Freedom in International Law, I wanted to offer a coherent way to accept that the communal exercise of religious freedom is extremely important, as we said, for education, worship, leadership in religious institutions, and also in order for people to stand up to the state, to the government, and demand that their rights be respected. All these can be done only or more effectively in community with others. But at the same time, I wanted to avoid the pernicious effect of a recognition of collective rights, which may potentially, actually, and sometimes even without much discussion, trump individual rights. So what I argued for is that religious rights should be recognized as individual rights, and rights of the group should be recognized as rights of the second order that are derived from individual rights, but can never, therefore, supersede them. This has become, I think, since publishing my book, an even more urgent issue, with even more problematic decisions cropping up, as can be evidenced by most of the examples I gave you tonight have, in fact, arisen after I published my book, so really in very, very recently. So I think the urgency of giving some thought to the matter and some coherent solution in international law has become even greater. So where next? My research has grown further afield from dealing with religious freedom only, other conflicts of rights, other decisions whether to recognize human rights as rights of individuals, of communities, where states stand in international law on these matters. These are all cropping up more and more, and I think decisions on these matters will have to be, again, given more thought, and conceptual frameworks need to be developed. In a book that will be coming out in the next couple of weeks, which I co-edited with other writers, we have looked at these issues in boundaries of state, boundaries of rights, human rights, private actors, and positive obligations. As you can see from the cover photo, we've covered the entire globe in that. But challenges still remain, both in understanding, interpretation, and enforcement of human rights. Thank you.
First Deputy Vice-Chancellor, ladies and gentlemen, well, thank you all for being with us this evening for what, without doubt at all, has been fascinating and stimulating and worrying, but has given you, I'm sure, a huge amount to think about. I'm David Chalk, and it's almost 10 years since I was appointed as the founding head of the Department of Law. Thanks. Yes. That is fairly staggering as an idea, and it occurs to me, actually, I was the Department of Law at that time. It was just I. But that means that it gives me a special pleasure, on behalf of the university, on behalf of the department, and on behalf of everyone here, to say thank you, Anat, for your inaugural professorial lecture. Anat's appointment as Professor of Law brings, as can be in no doubt at all after this evening, to the University of Winchester an immense expertise and experience in human rights and the relationship between religion, human rights, the individual, and the state. And her work complements the work that's being done across this university, and I mention in particular our Department of Theology, Religion and Philosophy, our Department of History, the university's Institute for Theological Partnerships, and our Winchester Centre of Religion, Reconciliation and Peace. And just mentioning those in one sentence shows you how enormous this subject is and how vital it is. Anat, tonight, in leading us in our thinking in terms not only of individual freedoms, but getting us thinking about collective freedom, the conflicts within and between all of that, you've given us a framework for thought, debate, and you've given a framework that I think is essential for the international community on these totally enormous issues. You've demonstrated your role as an academic, as a teacher, and as Professor of Law. So on behalf of everyone, Anat, thank you. Professor Anat Scolnicov.